Good afternoon and welcome to another episode of Lunch and Learn. And this is part of our Divorce Awareness Week, where we will be discussing certain aspects of divorces like we've been doing so for the last couple of days. And today's topic is divorce settlement. How do we negotiate divorce settlement? What are the practical tips and just how to go about going through this whole process with dignity? Good afternoon. My name is Eugene Opperman. I'm a family law practitioner. I've been doing so for the past 23 years, dealing mostly with divorces, matters pertaining to children's rights, as well as maintenance and domestic violence. And I'll be your host today in this discussion on specifically negotiations when it comes to divorce settlements. Just as a matter of interest, this webinar is brought to you free of charge. We have been streaming this all over South Africa to our social media platforms, LinkedIn, our YouTube channel, as well as a couple of Facebook channels or Facebook groups. And we welcome all our registrants, all those people that have been joining us for the last couple of episodes and sessions of Lunch and Learn. Most welcome to each and every one of you joining us today. Like I said, it is brought by our firm, sponsored by our firm, Oppermans Incorporated. If you do have any inquiries, if you have any difficulties with regards to divorces and so forth, you're most welcome to reach out to us. If you do not understand some of the content, please reach out to us, send us an email. You can send me a direct email on my personal email, eugene@oppermansinc.co.za, or you could use the Lunch and Learn inbox, info@lunchandlearn.org.za. So without further ado, what we will be discussing today, just as a overview of our discussions, of our webinar today. So settlements, what needs to be discussed during this whole divorce process? Ultimately, the aim is to reach a settlement between the parties. So what needs to be discussed? We'll be offering some discussions or some tips on how to navigate this whole process of settlement negotiation with dignity. We'll be addressing some of the pitfalls when it comes to settlement agreements and the drafting thereof, and then also explain to you what to expect from court. We have not addressed that, so we'll be addressing this today. What can you expect when you go to court? What is it that you need to say? What should you not say? And so forth. And then lastly, we will be discussing the influence of social media when it comes to divorce proceedings. How would that affect you, and the advice that we could give you. Just as a matter of logistics, if you have registered free on our website, www.lunchandlearn.org.za, you would have received a link bringing you to either to watch it on our webpage or on our social media. But if you have registered and you have received the link, you would also have access to our resource and templates folder, where you would have a copy of the slides that we will be discussing today, as well as a complete course handout explaining everything that we have just said. If we are referring to certain case law or any documents and so forth, that would also be available on the resource and templates folder for you to download and to watch this webinar afterwards as well. But without further ado, let's just jump right into it, and let's talk about divorce settlement. What needs to be addressed when it comes to divorce settlement? Now, there's basically four key factors that one needs to remember if you discuss divorce settlements. Number one, the thing that needs to be discussed is obviously maintenance to be made for either the spouse or for the children. Now, we all know that and as I've mentioned previously, is that the divorce court would not grant a divorce order or decree of divorce if it is not in the benefit of the children. So the maintenance payments of the children specifically needs to be addressed, as well as spousal maintenance. Another thing that also needs to be addressed is guardianship, custody, and access to the children. Usually with regards to guardianship, that is done through the High Court, but most definitely the custody and the access to children could also be discussed, the visitation rights and so forth, who pays what, who needs to pick up the children from school, and so forth. That could be governed by a parenting plan, or it could also form part of the divorce settlement in the settlement agreement. Another thing that also needs to be discussed is the division of assets, including the matrimonial home. That is usually a contentious issue. Who stays in the matrimonial home, who pays what, and so forth. So that is usually also a form of dispute point, where parties don't see eye to eye. They do not want to give up the house that they have been spending so much money on when it comes to the settlement of divorce. Obviously, other things that also needs to be discussed are things like the medical aid, who pays for the medical aid, who pays for the excess if the medical aid does not pay for that, the retirement plans, if there's a possibility that parties share in each other's pension funds. It might all be dependent on the marital regime that they are entitled to do the sharing of pension funds. That also needs to be addressed, and that also needs to be discussed and negotiated. Now, regardless of the marital regime that you are married into, it might be in community of property, outside of community of property, with or without the accrual. If you reach a settlement agreement, then that would in all probability be made an order of court if it is in the best interest of the children, if there are children in this divorce matter. So then you could basically override, to a certain degree, the marital regime. So the parties could agree to certain aspects. Now, as anything in a divorce settlement must be agreed upon, and the courts would not they would not interfere, because the court was not a party to the contract. It is basically a contract between the parties, and the court would not very likely interfere in the stipulations or the agreements between the parties, unless it is considered to be contra bonis mores, which is not something that might not be practical, or the community does not agree to it, or something like that. Then the courts might change the stipulations of the contract if it is not practically and judicially enforceable. Those are just basically the things that needs to be discussed. So, as a general point of departure, what does one need to look at when it comes to do the settlement? What is the mind frame and the mindset? Remember, we said that we are approaching this whole divorce week, awareness week. We approach it holistically. Instead of being very adversarial, pushing for litigation, let's see how we can actually negotiate and sit around a table and discuss things, have an open line of communication. So how do you prepare for that, and what are the things that you need to look out for? Number one is prepare yourself. If you're dealing with a narcissistic person, a person that might show narcissistic behavior, bear that in mind as well. But prepare yourself for open negotiation and discussions regarding reaching a amicable solution that is unique to your situation. Know what you want beforehand, and also know what you will be compromising on and what not. So have a clear idea in your mind of what are the things that are so important to you that you would not budge, and what are the things that you are willing to compromise. Because during the whole negotiation process, it is a give and take. It is a form of a mediation where parties sit around a table and they discuss and they listen to each other, and they hear the other fears and they hear the other demands. And it is an active negotiation process. But know beforehand what it is exactly that you want from this whole process. What are the things that is not negotiable, and what are the things, the issues that might be discussed and a compromise being reached there. In terms of divorce settlement, be honest. It is no use if you come with a hidden agenda, and it is just a fishing expedition and so forth. Be honest with what you want. Most of these negotiations are without prejudice, so it would not be enforceable in court. So the attorneys would not testify to that in court unless a settlement agreement is reached. So there is an opportunity for you and your spouse and the attorneys to sit around a table and to enter into meaningful negotiations in order to reach an amicable solution, an amicable mutually agreeable solution to a settlement agreement when it comes to your divorce. I also found that if parties explain the reasons for what they want, it gives a better understanding for the other party, the other spouse, of knowing where they come from. So as far as possible, explain your reasons. I want to stay in the marital home because X, Y, and Z. I want spousal maintenance for this, and the other reason, and so forth. I want access to a motor vehicle, so that it needs to be made provision for during the negotiations and the settlement agreement. And that is the reasons. I need to take the children to school, and so forth. So explain the reasoning why you want things, instead of just coming there with a whole list of demands. I want this, and I'd want that. Explain to the other party so that they actually understand where you're coming from. Approach an attorney or a skilled mediator to assist you. Negotiations might be quite tricky, especially when it comes to pension funds, the division of and the splitting of pension funds, the tax implications, and so forth. Know your rights and have a skilled attorney or a mediator on your side that could actually guide you through this whole process. You do not want to end up in a situation where after the fact, after the divorce has been granted, you realize that, you know what, I actually want this and I actually wanted that, because that might be too late. That ship might have been sailing. And you would not be entitled to that because you signed the agreement beforehand. So know your rights and get someone on your side that you trust. It might be an attorney or a mediator that could guide you through the process in order to make certain that you understand your rights and what your entitlement is with regards to the negotiations and the settlement. Take a break. You know what, negotiations are a two-way street. If at any stage you feel uncomfortable, or if you do not feel like you're feeling overwhelmed, you need time to process, take a break. Do not sit there and be bombarded with so many demands and so many things that you're basically overwhelmed and you just don't know. You just agree to it, and just in order to get the process over. Take your time and take a break whenever necessary. At any stage, if you are in an abusive relationship and you feel uncomfortable, please notify either the attorney or the mediator that you want some time out. You need a break for 5 or 10 or 15 minutes, or you can actually postpone the proceedings to a next event in order to safeguard yourself. Take care of yourself during this whole process. Obviously, avoid insults. This is not a mud throwing or mud slinging contest where you insult the other party. Steer away from blaming the other party. The main aim of negotiations is to sit around the table and to find an amicable solution to solving this whole problem, and in order to draft a settlement agreement to present to court and to finalize your divorce in an amicable way. So avoid the insults as far as possible. Last one there is listen. Listen to what the other party says. You do not necessarily have to agree with them, but just as you explain your reasons for your certain demands, listen to what they say and try and understand what their reasoning might be for asking certain things. Very vitally important. Do not sign anything that you do not understand. Do not get bullied by legal practitioners of the opposing party. If you're unrepresented, or even if you are represented, do not get bullied into signing anything that you do not understand and that you agree with. Remember, this is your negotiation. This is your chance to put forward your demands, what you want to compromise on, and what you are not willing to compromise on. So do not budge on things just in order to get the process over and done with. Do not sign anything unless you are 100% sure that is exactly what you want. Those are just some general comments and some general remarks specifically on negotiation. Another question that pops up quite often is parties come to me and we draft the settlement agreement, and then 2 or 3 days afterwards, then they have the typical buyer remorse, and they want to change the settlement agreement. Remember now, if you enter into an agreement with someone, there are certain elements of the agreement that needs to be abided by. And that forms the basis of a contract between two parties, and that contract stands unless there's something like undue influence and so forth. But that is a contract between two parties. In a recent case that was handed down last year in April 2022, AVW versus SVW, the judge actually mentioned this quite clearly. And I want to read from that excerpt from that judgment, where it says, where the judge mentioned that a new concerning trend appears that have emerged where parties settle a divorce action by signing a settlement agreement with the assistance of their legal representatives, only to thereafter, before such an agreement is made an order of court, decide that they no longer wish to be bound thereby. It needs to be remembered that, that regardless of whether or not an agreement between the parties was made an order of court, they are usually bound by that contract. So, yes, unless the contract is totally out of line and not in accordance with the legislation, the courts would not be prone for you to change that settlement agreement unless there is good cause and there's good reason for that. It might be something like undue influence, that you signed it where you did not understand. But again, do not sign anything unless you're 100% sure and you understand what you have been signing, because it is a formal contract and the courts might very well keep you to that contract. A further case, JN versus NN, where the question was indeed asked by the learned judge, can you change a settlement agreement after it has been signed? Now, this question was asked and it was answered. And in this specific case, also the courts reckoned that unfortunately for the applicant, the application to vary the settlement agreement was dismissed, because the court said that the court was not a party to that. It was a negotiation. Subsequently, after this negotiation, the parties reduced what they decided in writing. They both signed the settlement agreement, and that formed a contract, and the courts was not a party to that contract, so the contract would be enforceable and you can change it afterwards by just changing your mind. Now, a settlement agreement needs to contain a couple of key elements, and in the resource and templates folder, I've copied a standard that is a very standard settlement agreement, which I will go through quickly. That is just the basic elements that needs to be included in a settlement agreement. And if we go through that, let me just get to that screen. Now, the settlement agreement is, remember, it is a formal document that parties need to sign. So it all starts off with the applicable court, the citation, the correct citation of the correct court. If it's the regional court, then the regional court details needs to be put in there. If it's the high court, then obviously the high court details need to be there. Obviously, there would be a case number and the details, the name and the ID numbers of the plaintiff and the defendant. Usually I see what many of my colleagues also do is they put in a couple of definitions, what is meant by husband, what is meant by wife, the names of the children, and so forth. There's a preamble where they just say how are the parties married. They were married inside of community of property, outside of community of property, and so forth, on a certain date and a certain place, and they agreed that the marriage has been irretrievably broken down and that they would like to get divorced. That is just the preamble thereof. The consent paper or the settlement agreement also needs to deal with the immovable property. If there's any immovable property, please do include the earth number and the correct address and the jurisdiction, say for example, the jurisdiction and the province as well, so that the property is correctly identified. If the property needs to be sold, that could also be put in there. If it's jointly owned, then there should also be made mention specifically in the consent paper that it is jointly owned, and this is how it's going to be dealt with further off or just after the divorce. Movable property needs to be addressed. What I would suggest there is to compile a list of movable property that needs to be split. That's usually household items, who gets the TV, who gets the sofa, who gets the fridge, and so forth. Make a list and put the names there too, so that you could attach that to your settlement agreement as well, because that just makes it easier. The court will not venture into nitpicking to say, but you get this and you get that, and you get 5 teaspoons and you get steak knives and so forth. The court will not entertain that. The court will just simply say, you know what, this is the split thereof. So in order to make it easier for you, especially post-divorce, after the divorce, when it comes to the physical division thereof, that there's a clear list of how it needs to be divided. The dates in the joint estate also needs to be addressed. Who pays what? Together with, I see that many of the attorneys also include motor vehicles as a separate heading, although it falls under the movable property. But they make specific mention thereof, especially when it comes to one party paying the premiums of the motor vehicle, the other one pays for the insurance, who drives the vehicle, and so forth. So that is dealt with separately. Child maintenance also needs to be included. That's vitally important, because like I've mentioned, the courts would not grant a divorce order if the children's needs are not attended to properly. This could be much more in detail to say with regards to escalation, how it will escalate yearly, CPI index, or for a fixed amount. Those are all things that you have to negotiate, and that would be put into the settlement agreement. Medical expenses and how it's dealt with. If one of the parties needs to stay on the medical aid of the other party, get the details thereof together with the medical aid number, as well as the name of the medical aid, until for how long a period. Is it just for lifelong that they stay there? Is it only for 6 months, and so forth? If the children are on one of the parties' medical aid, stipulate that quite correctly, and also make provision for who pays for the additional over-the-counter medicine, what things that you do not necessarily need to go to the doctor for, to bring that into negotiations as well. Provident fund, which we discussed in the previous webinar, make certain that you mention the fund details correctly. You do not only cite the institution that deals with it, like Old Mutual or Liberty and so forth, because they manage a load of pension funds. Make certain that you put the details, and as well as the fund number there, if there's an entitlement there too. If the parties agree that they would not lay claim to the other parties' pension fund, stipulate that as well, to say, but you know what, they waiver their rights to the pension fund or the provident fund or the retirement annuities of the other party. That needs to be dealt with in quite some detail. Parental responsibilities and rights. If there are children involved, remember now, if there are children involved, the Office of the Family Advocate will also get involved. They would have a look at this settlement agreement to see if it is in the best interest of the children, and then they would endorse that. So the parental responsibilities and rights needs to be completed in quite some detail. Who gets contact, who gets primary care, what will be the visitation rights, and so forth. How would they have contact with each other, and so forth. That needs to be dealt with in the consent paper specifically. Spousal maintenance, if there is any talk about spousal maintenance, if the parties negotiated and agreed upon spousal maintenance, if it's up until death or just for a certain period of time, or it's for token maintenance, or whatever the case might be, that also needs to be dealt with in the consent paper. Remember now, specifically with regards to spousal maintenance, if you do not claim spousal maintenance in your consent paper, and the court does not make that an order of court, that you cannot claim spousal maintenance afterwards. You cannot come after the fact, after the decree of divorce has been granted, and then approach the court to say you want spousal maintenance. So this needs to be dealt with during the divorce proceedings, before the court makes a ruling, or the court actually eventually then makes a ruling thereupon. You cannot go to the court afterwards to say, but then now, after the divorce has been granted, that you want spousal maintenance. Issue of cost usually needs to be addressed, that it is a full and final settlement, that there's no variation. And this is quite interesting because it says that no variation of the terms of this agreement shall be of any force and effect unless it's reduced in writing and signed by both parties. Remember now I said that this consent paper, or this settlement agreement, forms the basis of a legal document. So any changes there to any variation thereof needs to be reduced in writing, and both parties needs to agree on that and then sign it. And then that would be considered to be a valid change therein. Order of court, that's just in your prayers that you want an order of court granted and that the settlement agreement should form part of the order of court. That is basically, in short, what needs to be contained in a settlement agreement. It's not a difficult document. Steer away from the legal jargon. Keep it as simple as possible, especially for the attorneys as well. We like to have all this legal big terms, but it becomes difficult afterwards when it comes to the enforcement thereof, and trying to enforce that afterwards. What is actually meant by this? Because what you try to use such big words that it gets lost in the translation of what is meant by the parties. A colleague of mine, Simon Dippenaar, is actually, he did a talk on specifically some tips on negotiation, which I would love to share with you, and it would give you some insight specifically to divorce negotiations. Over to you, Simon.
Are you going through a divorce? Have you thought about how you will negotiate the divorce settlement? Hi, I'm Simon Dippenaar and I'm a family lawyer. Now, there are 3 types of divorce in South Africa. It's contested, uncontested, and mediated. An uncontested divorce is the quickest and least expensive option. If you and your spouse are on civil terms, the best option is to work together to agree on maintenance, division of assets, childcare and contact, and other important decisions. You'll still need legal advice to ensure you don't overlook the more complex aspects of financial uncoupling, such as pension splitting, but you will save a lot of cost and time if you and your spouse agree on the basic financial structure of the divorce before you sit down with your attorney. If you can't agree on anything, your divorce will go to court, and the court will determine the terms of the divorce. A contested divorce can drag on for a real long time and rack up enormous costs, so try to avoid this if you can. If there is acrimony between you and your spouse, but you are on speaking terms, a professional mediator can help you negotiate and arrive at a settlement. Now, mediated divorce costs more than an uncontested divorce, but a lot less than going to court. With your divorces uncontested or mediated, you are going to have to negotiate your divorce settlement. By the time you reach the stage, you've already gone through an intensely emotional process, but don't falter now. You need all your focus and resilience. The divorce agreement you negotiate will have long-term consequences for your financial and emotional well-being. It's essential to approach the negotiations calmly, rationally, and well-prepared. I know it can be hard to remain impassive, but you loved each other once and now you both deserve to move on with dignity. If you have children, you will have an ongoing relationship. Sticking it to your spouse is hardly a good start to post-divorce co-parenting. Now, these tips may help. Don't defend a position. Look after interests. In other words, don't approach the negotiation with an immovable position in mind. Rather, focus on the need you are trying to meet. If you approach negotiations with a figure in mind and that figure is non-negotiable, you can wind up at a stalemate. Rather, know what you are trying to achieve, what outcome you need, for example, being able to stay in the family home or maintain a certain standard of living, rather than winning a maintenance claim. There are always multiple ways of structuring an arrangement. Focus on finding a workable solution that meets the need rather than a fixed monetary amount. Now, use your emotional intelligence. The person sitting across from you is not your enemy. You cared about them once and possibly still do, even if you no longer wish to be married to them. But treat your spouse with respect and try to understand what they are going through. Your knowledge of their emotional triggers can help you understand what's going on. Use your emotional intelligence to find more creative solutions to difficult issues. If you're prepared to meet a particular emotional need, they may be willing to ease up on a financial demand. Consider the significance of non-monetary possessions. Now, conceding a much-loved family pet, if you know in your heart it means more to your spouse than you, could create goodwill that will pay you unexpected dividends. Avoid saying hurtful things. Imagine how you would feel if the tables were turned. If they are turned, i.e., if your spouse says something hurtful to you, keep your emotions in check. Know that they are only trying to hurt you because they are hurting, and don't rise to the bait, however hard that may be. Be honest. Negotiations can only succeed when there is trust between the negotiating parties. For trust to be established, there has to be honesty and transparency. This may be difficult if one of the reasons for the divorce has been dishonesty in the past. Nevertheless, don't try to hide assets or financial information. Provide information they request promptly, meekly, and willingly. Operate in good faith, and it will stand you in good stead in the negotiating process. Now focus on the problem, not the person. You have decided to divorce for whatever reasons. This is not the time to dredge up old arguments. You need to arrive at an agreement that allows you both to move to the next stage of your life as smoothly as possible. That's the shared problem. So set aside your emotional issues. Distance the problem from the person and focus on what needs to be done and how you're going to do it. Communicate. Both during negotiations and in preparations, effective communication is key. Express your views clearly. Focus on what you feel and what you need, not on what they have said or done or not done. As a family lawyer, I've observed and supported many divorcing couples. This advice is the result of long experience. I hope it helps you navigate a very difficult time.
Thank you for that, Simon. Next, I would like to discuss some of the pitfalls that we have in practice. Now, I've been doing divorces for quite a number of years, for 23 years, and I've probably done a couple of thousand of divorces. And there are certain pitfalls when it comes to divorce that I would like to share with you to make it easier for you, and things that you could be wary about in order to make it easier for you. Number one is, as soon as possible during this whole divorce proceedings, make a list of assets that needs to be divided. Go through the home, make a list, take a spreadsheet, and everything from the portraits against the wall to the wall hangings, the curtains, the number of sets of duvet covers, and so forth, because that needs to be split amicably between the parties at the end of the day, so that you do not come back and you add on as you go along. So if your spouse is amenable to that, maybe you could do that together, but otherwise, I would suggest that you go through the house room by room and then create a list of assets that needs to be divided. Specifically, make mention of what you want. What is the items of that needs to be split that you want, that is not negotiable, and then assets that your spouse would like. Your spouse would like maybe to have the Weber braai. You don't have a need for it. Without being spiteful, you know what, you can give that to him at the end of the day, if you're so inclined. Make provision for some of the things that might be forgotten. And how that would be dealt with. Usually what happens is that they forget about something that is stuck away in the attic or in the basement somewhere, and they clearly forgot about that, and that is not on the list. Make provision on the list that there might be things that you omitted, that you forgot about, and how that would be dealt with. Most often what happens is that those type of things, a value gets added to that, and then the value gets split in half to each of the parties. Also be clear, if you stay in the matrimonial home, make very clear, make certain who pays what until the divorce is granted. Who pays the rates? Who pays the taxes? Who pays for the utilities? Who pays for the DSTV? Who pays for the internet? Those are all the nitty-gritty stuff that needs to be sorted out, because you do not want to be left in a situation where you stay behind in the matrimonial home and then the power gets cut because the spouse that usually pays for that just decided that he's not going to pay anymore, and you sit without electricity. So make certain that those nitty-gritty, the day-to-day running of the house, all those nitty-gritty stuff needs to be identified and to be discussed and negotiated as well. Transfer of assets, if you're in a position where where the property is on your name and or you buy out the portion of your spouse, and there needs to be documents signed. It could be transfer of property, it could be a vehicle, and so forth, that you make provision for that if the other party is not willing to sign that documents, that there's another way, an alternative way of signing the documents. Now, usually what happens is that we note in the settlement agreements that if one of the parties are reluctant to sign those type of documents, that the sheriff of the court might be authorized to sign on that party's behalf if they do not sign within a certain period of time. Very important, make certain that you address the issue of spousal maintenance. Even if it's just token maintenance of only R1, and token maintenance we'll discuss tomorrow. Spousal maintenance is vitally important because you cannot go back to the court claiming spousal maintenance after the divorce decree has been granted. So that needs to be addressed during the whole process of negotiation. Use clear language. When you draft a settlement agreement, use clear language. Steer away from legal jargon, Latin phrases, and so forth, because most of the lay public out there, and even most of the attorneys, do not understand most of these legal jargon that they use, the Latin phrases, and so forth. Plain, simple language is more than enough. Make certain, that's also one of the pitfalls, make certain that you use the correct pension fund details. That is vitally important. I see that so many times, that people are entitled to pension benefits in terms of the marital regime, but the wording of the settlement agreement was so dismally incorrect that the fund point blank just refuses to pay out, and then you have to approach the court again for a variation thereof in order to get your pension fund payments. So make sure that the citation of the pension fund, together with a name, with the details and so forth, is correctly drafted in your settlement agreement. Also make certain about the tax implications. You do not want to have the anticipation of a payout in terms of a pension fund and then get slapped with a big SARS bill at the end of the day as tax implications. So make certain that you address tax implications as well. On our next slide, navigating the process with dignity. Remember that this whole process of divorce is an emotional process, but you can go through this whole process with dignity, with your own dignity intact, which means that you try to navigate your way throughout this whole divorce with as little as drama as possible, while maintaining your own dignity and your own honor for yourself. This is not something that you do for the other party. That is something that you do for yourself, to empower yourself and to come out a better person. And I found that in most instances, going through a divorce with dignity actually means that you separate your emotions from the process, that you leave all the nitty-gritty and you leave all the negotiations and all the difficult aspects of divorce. You leave that for the legal practitioners to sort that out, because that is what they are getting paid for. That is what they are good at. And so that you can actually just focus taking care of yourself and going through this whole process with dignity and coming out with dignity. So what happens in court? That's also, some of the people are scared of court. They don't know what to expect. Now, there's a difference between the uncontested and contested divorces. The uncontested divorce obviously would mean that testimony needs to be led by both parties, and it is a longer process. But if I explain the uncontested divorce is usually where the parties have reached a settlement agreement. In practice, I usually meet up with my client beforehand, and I would explain to them the process that needs to be followed so that they are not surprised by what type of questions would be asked in court. So it would all start off with by you taking the oath. Remember, it is done in open court. So you would be expected to take the oath, to swear that you will tell the truth, the whole truth, and nothing but the truth about the evidence that you're about to give. there would be a confirmation that you are the plaintiff. Usually the attorney would stand up and to say, but he represents you, and that you are the plaintiff in this matter, and that you would confirm that. So you would basically just say, I confirm that I'm the plaintiff, and this is my husband, or this is my spouse, and that is his name, and he is the defendant. There would also need to be a confirmation of address. That's just in order to establish the jurisdiction, to say, where do you live? Do you live in the jurisdiction of this honorable court? That is just a leading question, and you just answer in the affirmative. I live in this area, and that falls under the jurisdiction of this court. Also, you need to establish that you are still married, the marriage still subsists, and that you are married to the defendant. And you also need to give information regarding the marital regime. So basically, we would just ask you, you are married to the defendant. Is that correct? Yes. And you are married in community of property or outside of community of property. Is that correct? Yes. And then by that stage, you would hand up the marriage certificate. Remember, you need the original marriage certificate. So if you do not have the marriage certificate beforehand, then go to Home Affairs in order to get a copy thereof. If you are married outside of community of property with the accrual, then you would also need a copy of the antenuptial contract that needs to be handed up to court, and that would form part of the court bundle and evidence of court. The next issue that needs to be discussed, and that would be asked for you in court, would be, were there any minor children born from this wedding? And if you say yes, what are the ages of the children? It's basically just the names and the ages of the minor children. The next question would be, if there are minor children and the Office of the Family Advocate has endorsed your settlement agreement, is that the attorney would make mention thereof to say, but the parties entered into a settlement agreement. It was submitted to the Office of the Family Advocate, and it was properly endorsed. That's basically it. Then a simple question. This is usually where most people struggle, and they're fearful, because the attorney would ask you, could you explain to the court what is the reasons why you allege that the marriage has been irretrievably broken down in your own words? And this is usually where you say things very general, without dirty laundry being washed in open court. You would say simply things like, we've lost all the love and respect. We have not been staying as husband and wife for a certain period of time. I am in an abusive relationship. I moved out, and I haven't lived with a defendant for a certain period of time. Anything that could form the basis of your divorce would be mentioned there. Like I said, not much detail. The courts are not interested in all the dirty washing and all the juicy details thereof. They just want to make certain that the marriage has been irretrievably broken down. After that, we're nearing the end of the court proceedings. The attorney would usually then take out the settlement agreement and ask leave from court to approach you to give you a copy of the settlement agreement. And the attorney would ask you, can you confirm whose signature is above that of the plaintiff? You would obviously say that is you. That is your signature. Who is this? Whose signature is above defendant? You would say it is your spouse's signature, and that is basically it. If the court, some of the courts actually do that, they would ask you to elaborate on the specifics, on the provisions for the children, as mentioned in either the parenting plan or the particulars of claim. How will they be supported? Because remember, like I said, the court will not grant a divorce if it's not in the best interest of the children. Then basically the attorney would ask for the prayers to ask that the settlement agreement be incorporated in the decree of divorce, and the attorney would simply sit down, and the magistrate would make a couple of notes on the file, and after reading through all the documents, the court would then grant an order of divorce. It is simple as that. Do not expect any streamers. Do not expect a loud applause. It is a very underwhelming situation going through this whole process. And if you are attorneys doing many divorces like I've been doing, the whole process would probably take in the order of between 3 and 5 minutes. in order to complete. But like I said, do not expect any fireworks, no streamers, no applause, nothing like that. It is really an underwhelming experience. Bear in mind that they do not give you a divorce decree, the paperwork. They do not give that to you immediately. They would only give that to you, make that available about 5 to 10 days after the court hearing. But you are considered to be divorced when the magistrate or the presiding officer or the judge says that an order of divorce has been granted. In most instances, it is expected from you to take that document, the divorce decree, to the Home Affairs office closest to where you live and hand it in there so that they could update their details. I found that in so many instances, people neglect to do that. And then 2 or 3 or 5 years afterwards, once they want to remarry, if they are still listed as married at Home Affairs. So please do take care of that and make certain that as soon as you get the divorce decree, that you make copies thereof and then submit one to Home Affairs. My suggestion would also be that as soon as you get the divorce decree, make at least 10 or 15 copies and have your attorney certify that as true and correct, or as a copy of the duplicate, because you would need to have copies of your divorce decree for now and ever, at least 15 copies. You would need that for opening new bank accounts, for changing of names on banking accounts if you want to change your surname again. Those are all the instances where you would need a copy of your divorce order. So make enough copies thereof, keep that copies at hand, because you will most definitely use that in future as well. The influence of social media, that brings us to the last portion thereof. Now, so many people live their lives vicariously through Facebook, through all the other social media platforms. And I found that having dealt with so many divorces, that social media posts can actually exacerbate the whole difficult dynamics of divorce proceedings. Staying off social media can help divorcing people focus more on their family and on themselves, rather than post their hurt, their rage, and so forth in the public domain. Well, when posting during the divorce, let me just go back to the previous slide. When posting during the whole divorce procedure, try and aim to avoid posting any negative posts about your spouse. Because you would open yourself for retaliation and possibly for the other spouse to obtain an interdict against you from removing and forcing you to remove the comments that you make on social media. Very interesting. There was a article in Psychology Today that was written, that was published on the 9th of November in 2021, where they said that some divorcing people take to social media to vent or to rage or to seek support. Now, that is quite often the case where they reach out to people, friends and family over social media, because they might be scattered all over South Africa, in order to seek some kind of support. But on the other side, they might also use it to vent or to rage, to bitch and to moan about this whole divorce proceedings. Others go to social media when they are in pain in order to just get it out there as a way to vent. And then they see the post that makes them believe that the other spouse, the spouse or everyone else is having a great time and you not. And in all probability, your spouse will be doing exactly the same and checking out your Facebook profile or your social media profile. Don't assume that he or she is having that ecstatic, blissfully happy life as based on their Facebook posts, because most of these happy posts can actually increase your grief, your rage, and your jealousy if you see posts on social media where your spouse is actually moving on and you are not. So steer away from living your life vicariously on social media platforms during this whole divorce process. What I advise my clients, and we've got a checklist giving those to the people, I urge them to stop using social media during this divorce process. And if you have to stay on social media in order to stay in touch with your support system or your family and your friends, don't post any negative things on there. If you really want to post something positive, something that would uplift your spirit, showing that you are going through this whole process with dignity and without any grief, resentfulness, and so forth. Very important, change your privacy settings to the highest levels. People tend to forget that, and we will be addressing that probably tomorrow. Change your privacy settings so that your spouse might not stalk you on your social media platforms. So change your security settings either on Instagram, on Facebook, on LinkedIn, and so forth, so that they do not have access and they cannot see your post. Obviously, there would be instances where they would have access there to via the shared friends and family, but at least they would not be able to comment on your Facebook page or your Instagram posts. If you feel comfortable there too, remove your relationship status. That in itself might also create a sense of empowerment if you take the first step of removing your relationship status. Do not discuss your case online. That is vitally important. Do not live your life, like I said, vicariously through Facebook and discuss your whole case. Remember, that case up until the stage that the judge has made or the magistrate has made a ruling is sub judice. There is a court case pending. So do not engage into conversations asking for advice and so forth on social media. That is an absolute no-no. Another thing is, do not stalk your ex. Do not look for dirt on your ex online, stalking his Facebook profile or his Instagram profile and so forth. Very seldom is that used as evidence because at that stage, it cannot be used in court because it needs to be discovered. It needs to form part of the whole discovery process. So there's actually no need for you to gather all the dirt and so forth with regards to your spouse's whereabouts, what he does not do, and so forth. And please don't post intimate images or videos of your marriage. The typical revenge porn, do not do that. I've had a couple of clients doing that where I was quite disappointed. So please do not do that. Steer away from posting any negative pictures and so forth of your soon-to-be ex-spouse when it comes to divorce proceedings and during this whole process leading up to the finalization of the divorce. That is basically us for today. Just a reminder that if you want to download any of our free ebooks, it was written by personnel of our office, myself included. It was written in plain English. There's no legal jargon. It is quite straightforward. You're most welcome to download any of these ebooks. The latest one that we've included was the Divorce with Dignity, where we discuss mostly the mediative process and the amicable way of going through a divorce proceedings. And then the other one that we also included was specifically how to deal with economic abuse, which we will also be addressing tomorrow. You're most welcome to download any of those ebooks free of charge from our website, www.oppermansinc.co.za. This Divorce Awareness Week was proudly sponsored by our firm, Oppermans Incorporated. If you do have any questions pertaining to your divorce or would like to have assistance or any questions with regards to what has been said during the webinar, if you do not understand some of the concepts, please do reach out to us. Drop us an email. You can either send it to me personally, eugene@oppermansinc.co.za, or you could send it to our normal inbox at Lunch and Learn, info@lunchandlearn.org.za, and we would get one of the attorneys or the candidate attorneys to assist you with this matter. Thank you so much for Erin for compiling the handout, as well as Simon for also joining us and giving some insight from his perspective as well. Thank you so much for joining us. For all those that registered, thank you so much for that. The bookings for the next Lunch and Learn session are already open, so please venture over to our website if you want to book for future sessions, which is all presented free of charge by our officers. And that is basically a wrap from my side. Thank you so much for joining us. My name is Eugene Opperman. I'm a family law practitioner, doing so for the past 23 years with a passion for child maintenance, divorces, matters pertaining to children, as well as domestic violence. Thank you so much for joining us. We'll see you soon for a next session of Lunch and Learn. Please do have a good afternoon further, and please read the disclaimer at the end of the slides. Thank you so much.